Good morning, and thank you for joining us for the July edition of Bracewell's Environmental Essentials webinar series. I'm Whit Swift with the firm's Austin office, and I'm taking on the webinar this month and offered to do so really early July when EPA took a couple actions that are aimed at expediting air permitting. There have been a couple other significant permitting related developments this summer that generated questions from clients, and I thought we could just package all of them together for a short review of these federal developments affecting air permitting. As the slide says, it's been an eventful summer. I'm going to focus on the four things that have happened since the end of May, and they're listed here in chronological order from most recent to oldest. They are first, an early July proposed rule that would seek to change minor new source review public notice requirements in state SIPs. Second, an EPA guidance memo regarding non-attainment new source review and the timing of acquiring offsets. Third, the court decision not affecting really the 2024 PM 2.5 annual NAAQS. And last, EPA's proposal regarding the definition of begin actual construction for purposes of federal NSR permitting. You've likely read about the administration's goals regarding dominance in data centers and artificial intelligence. And three of these four topics, the three where EPA is actually doing something about permitting, I think can fairly be viewed as EPA taking action to facilitate faster permitting and construction of data centers, though all three of these equally benefit other stationary sources that are subject to permitting requirements. The fourth, the DC Circuit's decision and the PM 2.5 NAAQS, is more of a thing, of course, that happened to EPA. And if anything, that decision will make permitting harder for stationary sources. But let's dive in. The first topic we'll discuss is the minor new source review public rule or public notice proposal. On July 1st, EPA released a pre-publication proposed rule that seeks to change the federal standards for state implementation plans, or SIPs, for public notice of minor NSR permits. It was published in the Federal Register on July 7th, and the citation is here on the slide. The proposal would only affect minor NSR projects, that is, new sources or changes to existing sources that do not trigger prevention of significant deterioration or non-attainment new source review, or federal NSR, or alternatively called major NSR, depending on whose program you're dealing with. But again, this is a rule change that would affect minor NSR projects, not those that are a new major source or a major modification of an existing major source. EPA's rules in 40 CFR Part 51, Subpart I, establish minimum SIP requirements for state minor NSR programs. That is, for the state to have a minor NSR program SIP approved by EPA, that state program must meet the minimums set forth in Subpart I. And one of those rules, Section 51.161, establishes the public participation requirements for state minor NSR programs. In the preamble to July's proposed rule, EPA states that the Federal Clean Air Act, for NSR actions that are not subject to PSD or non-attainment new source review, for those actions, the Federal Clean Air Act does not explicitly require public notice. And seeing that EPA's regulatory requirements go beyond what is required by the Clean Air Act, EPA has proposed to remove that public notice requirement from its rules in Section 51.161. Now, if EPA were to adopt this change, it would not force states to eliminate public notice for minor NSR permit actions, but it would allow states to eliminate those requirements and still have an approvable minor NSR SIP. So minor NSR requirements relating to public notice would not immediately go away. But the states that do have minor NSR notice requirements in their state rules would have the ability to drop those provisions and still have an approvable SIP. So this last bullet, what about Texas? I don't think that this will have an effect in Texas. The minor NSR public notice requirements are not in the TCEQ rules solely to comply with the requirements of Section 51.161. Rather, there are notice requirements established by Texas law in the Texas Health and Safety Code. The Health and Safety Code, which part of the Health and Safety Code is the Texas Clean Air Act, but in Section 382.056 of the Texas Clean Air Act, there's a requirement for public notice for NSR applications, and that requirement does not distinguish between major and minor NSR. There are, of course, minor NSR authorizations in Texas for which public notice is not required, but the Texas Clean Air Act has this blanket requirement for NSR permits from TCEQ to go through public notice. The exception in the rules is the one that I'm sure many of you are familiar with, where there's public notice de minimis applications. So there is a subset of minor NSR amendments in Texas that don't have to go to public notice, and they are those with emissions increases below the TCEQ's public notice de minimis thresholds. But again, that's a difference. There's a subset of minor NSR applications that by law and then rule don't have to go through public notice. But those are driven by Texas statutory requirements and not done to comply with the federal rules in Section 51.161. So my view is that this federal rule change alone, even if finalized, would not result in any immediate changes or really changes at all to the TCEQ's minor NSR notice requirements. They're there to establish or to implement Texas statutory requirements and not just what's in the Code of Federal Regulations. I think a reduction or decrease in minor NSR public notice requirements for Texas sources would require legislative action here in Texas. Moving to the next slide. The second topic relates to non-attainment new source review permitting requirements. Now, non-attainment NSR is triggered when an applicant seeks to authorize a new major source or a major modification of an existing major source in an area that is a non-attainment area for one of EPA's national ambient air quality standards. And the increase in emissions for that project or for that new source exceeds the federal new source review threshold, and it's the non-attainment pollutant or a non-attainment pollutant for that area that exceeds the federal threshold. An example would be a project in the Houston, Galveston, Brazoria ozone non-attainment area that seeks to authorize an increase in emissions of the ozone precursor VOC that's above the applicable major modification threshold for the Houston, Galveston area. Projects that trigger non-attainment new source review are subject to more stringent requirements than PSD projects in attainment areas. And the two key differences that you fall into when you're a non-attainment NSR application are, first, you've got to demonstrate that the new or modified sources will employ lowest achievable emission rate technology to control emissions of the relevant non-attainment pollutant. So LAIR, as it's called, which can be more stringent than best available control technology, or BACT. And second, relevant for our discussion here, the applicant must get offsets for the new emissions of that non-attainment pollutant that's increasing above significant levels. Offsets are more or less designed to take emissions out of the airshed in an amount that is greater than the new emissions that are being authorized. So, for example, in a severe ozone non-attainment area, the offset ratio is 1.3 to 1. So if you're authorizing a 100-ton increase of NOx in the Houston, Galveston, Brazoria ozone non-attainment area, to satisfy your offset requirement, you would need 130 tons of NOx offsets. This offset obligation is most commonly satisfied with emission credits that can be banked and traded under the TCEQ's Chapter 101 Emissions Banking and Trading Program. So now the development. On July 1st, EPA released a guidance document And that document identifies some inconsistency in EPA's past guidance with regard to the timing of when a permit applicant must have the offsets in hand, and notes that some permitting authorities will require the applicant to have those offsets at the time of permit issuance. That is, you need to have acquired and have the offsets ready, your emission credits ready to be retired in order to get the permit issued. The memo that was issued on July 1st says that this is unnecessary based on their reading of the Clean Air Act, and that an applicant should not be required to have the offsets for permit issuance, but rather, as long as that the permit requires that those offsets be acquired before the start of operation, that is, when the emissions increase will actually occur, that satisfies Clean Air Act requirements. Again, the bottom bullet. So those of you dealing with Texas projects, I really don't see this as changing anything. TCEQ already uses this same timing, and the TCEQ non-attainment NSR permits that I've seen include language that require the offsets to be acquired before starting operation of the project that triggered non-attainment NSR. Those of you dealing with permitting in states other than Texas, depending on how that state has handled this issue, this could make a meaningful change in non-attainment permitting, possibly allow permits to be issued sooner, and certainly provide additional time to secure any required offsets. This next development is not an EPA regulatory reform, but rather this court decision on the PM 2.5 annual NAAQS. EPA in 2024 had adopted a rule significantly lowering the PM 2.5 annual standard from 12 to 9 micrograms per cubic meter. A number of state and industry petitioners challenged the legality of EPA's action and the adequacy of the review that led to EPA lowering the PM 2.5 NAAQS. This occurred during the Biden administration, and it was performed, that review and the lowering of the NAAQS was performed by the Biden EPA. The Trump EPA has stated that it does not support the lower NAAQS, that is the 2024 standard, and rather than defend the prior administration's decision to lower the NAAQS in court, EPA actually asked the court to vacate the 2024 standard. This court decision has been pending for a long time, and that's the decision that just came out in late June. And the DC Circuit declined to vacate the standard, and it upheld the lower 2024 NAAQS standard. That is the 9 micrograms per cubic meter. Now, the Trump EPA has for a long time been stating that it wanted the NAAQS to be changed, but focused its strategy on courts rather than engaging in the regulatory process that would be required to evaluate, propose, and adopt a revision of the NAAQS, presumably a revision of the NAAQS that would increase the number from something higher than 9, possibly back to 12, but some sort of increase. That strategy, as of June 26, did not work. And so the question is, where does EPA go from here? Talked with my Washington, D.C. colleague, Brittany Pemberton, about this on a number of occasions. And there are a few things that EPA can and likely will do. One would be for EPA to embark on the regulatory process to actually reconsider the 2024 rule and, again, undertake its own rulemaking following the same sort of abbreviated mid-cycle review of the NAAQS that the Biden administration had performed, and propose and adopt a final rule changing the NAAQS. There are questions, however, whether EPA's got the time to do that at this point, given the type of review that is typically performed for evaluating whether the NAAQS should be changed. EPA could also further pursue this court case. That is, seek rehearing by the full DC Circuit. Per Brittany, you wouldn't normally expect EPA to pursue this route because there isn't necessarily a great likelihood of the full DC Circuit overturning the decision of the panel that the decision that the panel issued at the end of June, but it could delay the effectiveness of the court's decision, and delay may become a key element of EPA's going forward strategy. EPA could also appeal this case to the U.S. Supreme Court. As we've talked about or all seen over the past few years, this current makeup of the Supreme Court has shown an inclination to strike down some of EPA's actions. And so EPA may have better luck making the same arguments in a different and more conservative forum of the U.S. Supreme Court. But regardless of the path that EPA takes in the courtroom, EPA is expected to attempt to delay the non-attainment designations that it is required to make under the Clean Air Act for the 2024 standard. As the slide notes, EPA had a February 2026 deadline to make initial designations of non-attainment areas under the annual PM 2.5 standard. And it's already facing litigation to force those designations to be made because EPA missed that deadline. EPA can grant itself a 1-year extension based on having insufficient information to make those designations and is expected to do so, though there is some uncertainty that possibly could work in EPA's favor as to when the clock starts on that 1-year extension. Does it start on February 7th of 2026 when EPA was supposed to take the action under the law? Or can the start date of that 1-year extension be some later date tied to the effectiveness of the court decision that it upheld the 2024 NAAQS? And that delay is important, and when that delay starts is important. One reason is because of the anti-backsliding provisions of the Clean Air Act. We've discussed this internally as a practice group, and those anti-backsliding provisions could end up resulting in the PM 2.5 non-attainment area requirements sticking, even if an area is designated non-attainment under the 9 micrograms per cubic meter standard, and that same area would subsequently be redesignated as attainment under a higher standard. So there is some risk that, again, if EPA has to go through the designation process, even if subsequently the NAAQS changes, there could be non-attainment requirements that stick around due to those anti-backsliding provisions. And as the slide notes, this PM 2.5 decision also has serious NSR consequences. In the future, if areas are designated non-attainment, you will have non-attainment NSR requirements that kick in those areas that are non-attainment with this standard of 9. And more immediately, this means that the NAAQS will stay at a level of 9 for purposes of PSD modeling demonstrations for projects in attainment areas. When you're getting an air permit, you've got to demonstrate through air dispersion modeling that your project will not cause or contribute to an exceedance of the NAAQS. And this is a serious challenge for many areas in Texas and elsewhere because the background concentration is very close to 9 micrograms per cubic meter, the standard, and passing modeling is a great challenge with even the slightest increase in what the model predicts from the source itself. There's just no room. And you can't get an NSR permit unless you can model in. And this pressure has already been on ever since the NAAQS was changed in 2024. And this just confirms that that is not going away in the near future. So the pressure to avoid triggering PSD for fine particulate stays present. And when that's not possible, figuring out how to get modeled impacts below the significant impact level or SIL will be very important, because if your project is below the SIL, then you don't have to worry about a full PSD modeling demonstration below the NAAQS. But these NSR challenges will continue based on that, the court's decision. And so you'll see applicants really scrutinizing emissions calculations and assumptions, scrutinizing the modeling, looking at any refinements, really anything and everything to get those projects below the sill. And I know there's been some talk about what could be done to provide additional flexibility and modeling guidelines, higher sills, justification for higher sills, other items. Heard talk about using some sort of offset type of measure, even though you're not in formal non-attainment yet. But those would presumably require credit markets to develop for areas that don't have a mature credit market for PM 2.5. So there are some real challenges here, and those PM 2.5 permit challenges are going to be around for a while. Now, the last of our topics is relates to EPA's proposed rule that came out at the end of May, in which it proposed to make some changes to the Part 52.21 rules regarding the PSD program that are aimed at allowing permit applicants to perform more construction-related activities prior to permit issuance. PSD permits are pre-construction permits. That is, you must have the permit issued before you can begin actual construction on the emission units being permitted. Those of you in the airfield know that there are a number of EPA determination letters issued over the years that interpret and apply these requirements. And those letters are available on EPA's website and treated as guidance by the regulated community when trying to answer these questions. Trump's EPAs have been looking at this for many years. There was a draft memorandum that was never finalized on the topic back in 2020. And then last year, EPA issued a new permitting determination, the most recent one on this issue of what is construction, that disagreed with certain earlier EPA determinations that had taken a more expansive view as to what EPA considered beginning actual construction. And so now we have this new proposed rule. The issue is, of course, what physical on-site construction activities can be done before obtaining an NSR permit. Two key definition changes in the proposed rule. First, EPA proposed changes to the definition of begin actual construction. That is a definition that's there in Section 5221, where the current rule language refers to initiating construction activities on an emission unit. The proposed change would refer to initiating construction of pollutant emitting activities on a stationary source. And as part of that, EPA added a series of explicit exclusions to the definition, none of which are in the current definition of begin actual construction. The language is here on the slide. I won't read the whole thing, but I wanted to draw your attention to the highlighted language. This is certainly what caught my attention. And it's there's part of the third numbered item among the exclusions from begin actual construction is excavating land, including blasting or other removal of hard rock. I highlighted that language because, as I see it, that is definitely a change from what EPA and states have said in the past. Looking at the rest of the list, I'm pretty comfortable. I think I'd be comfortable advising someone that these other numbered items, basically everything not highlighted, are things that there's guidance out there that would support you undertaking that work prior to having your permit. So even without this rule change going forward, I think a lot of these listed items are through past EPA guidance, not part of beginning construction. But I do think that the highlighted language there is definitely new and would definitely allow additional activities to take place. Here's the other key definition in that proposal, and this is a brand new definition and one that ties into the definition of begin actual construction and how EPA is changing it to focus on construction of pollutant emitting activities. So EPA has proposed a new definition of what is called pollutant emitting activities. The bulk of the definition is a list of exclusions. That is, things that EPA says are not pollutant emitting activities. Like the prior slide, I've highlighted a couple of key areas that caught my interest. First, it's number 4 on the list of exclusions, and it relates to foundations. Now, excavation and foundations, those are things that are often We get a lot of questions about that type of work, and that EPA guidance, these determinations in the past have said no to doing foundations prior to permit issuance, or certainly at least foundations for emission units. So here you have clearly some language that is allowing or not treating foundations as pollutant emitting activities, but note that it's only for foundations without specific design elements configured for equipment or components that will emit pollutants. I'm not an engineer, but based on what I've seen on things like commercial buildings and homes with all of the precast ducts and plumbing and pipes that stick out of the foundation long before something is actually put on top of it, I'm really not sure how much this proposed language would allow as far as foundation work for emission units. I'd expect that a foundation would have the types of design elements that are identified here for the permitting equipment that was going to sit on it. So I'm really not clear how much leeway this would provide for foundation work for an emission unit. But I think from the proposal, you could tell that EPA was not comfortable just proposing that any foundations could be poured as long as you didn't assemble the equipment that will ultimately rest on top of that foundation. The second item here is number 7 that I've highlighted, and tie-ins. I think this also represents something new that you could do should this rule language be adopted as a final rule, and different from some past EPA determinations. There was some language in some of those past determinations about changes intended to accommodate an emission unit, and that was part of what it considered start of construction or begin actual construction on the emission unit. So I think here, if you're talking about sealed tie-in, some blind flange, something like that, that a future unit could tie into, I do think here that number 7 is some important and valuable work that you could do without having a permit. But not unlike the prior slide, I do think that the rest of the items on this list, the non-highlighted stuff, are areas where I think most applicants would look at it and say, yes, even without this proposed rule going final, I can do this type of work. And it's the type of work that past EPA determinations have allowed folks to undertake prior to getting their permit. As far as the procedural posture of this rule, the comment period closed at the end of last month, and final rule adoption to be determined. I'll note real quick here that the TCEQ did file comments on the proposed rule. TCEQ stated that it supported the changes, wanted EPA to recognize that this is at-risk construction. But importantly, TCEQ said that EPA should leave it up to state discretion as to whether or not the state needs to submit a SIP revision to incorporate these changes. So there are our big 4 developments. I threw in a bonus slide here for you. I'm not going to talk about them, but you can at least see them. And it's really more of a reminder of other developments that have happened, but these all occurred prior to this summer. The potential impacts of the GHG endangerment finding rescission, some prior guidance on federal NSR relating to reactivation policy, how to calculate whether you have a significant increase in emissions, and a Title V proposal on the scope of applicable requirements. So these are all just things that have come up, things that we get some questions on every once in a while. And so I wanted to throw in this little bonus reminder slide, even though we won't talk about them in any detail. And hey, there I am before I started wearing my glasses all the time. I hope you found this helpful. Please feel free to reach out if you have questions about any of these items I've discussed this morning, anything about that last sweeper slide that covered stuff that happened prior to this summer. And if you're coming to Austin for the Texas Environmental Super Conference in a few weeks, please join us at the reception we'll be having at the fairground at 111 Congress Avenue on Thursday evening. I promise that if you mention you heard about it on this webinar, I'll make sure you get unlimited free food and drink. Thank you again for joining this morning, and we'll see you next time.